The question has been agreed to by a majority of each of the two groups of members, so I declare the question carried. So I order that in the event of further divisions being claimed at this meeting in respect of the Electoral Legislation Miscellaneous Amendment Bill 2014, and we proceed forthwith to the division after the bill has been run for 1 minute. Clauses 5, 8, 13, 16, 17, 19, 22, 23, 25, 27, 28, New 7A, Schedule 2 amended, postponement and adjournment of general election and by-election. New 10A, Schedule 1 amended, postponement and adjournment of ordinary election and by-election. The Secretary for Constitutional and Mainland Affairs has already given notice to move amendments to clauses 5, 8, 13, 16, 17, 19, 22, 23, 25, 27, 28, and to add the new 7A and new 10A. Members may, in relation to the original provisions and the CSAs, to be moved by the Secretary, and the new clauses to have a joint debate. After the joint debate, the committee will first vote on the amendments moved by the Secretary to clauses 5, 8, 13, 16, 17, 19, 22, 23, 25, 27, and 28. If the CSAs of the Secretary are passed, then the committee will deal with the new 7A and new 10A. Secretary, you may now move the amendments. Mr. Chairman, I move the CSAs to clauses 5, 8, 13, 16, 17, 19, 22, 23, 25, 27, 28. We propose to have technical amendments so as to provide for greater clarity and accuracy for provisions on the extension of electoral deadlines in case of inclement weather. And in fact, in response to the suggestions and views of the members of the electoral and their legal advisor, we would like to propose a new 2A4 to the EAC Electoral Procedure Regulation, Cap 541D. And we would also like to have the new clause 2A4 so that we'll make clear as to which specific, as to the increment, whether general provisions are subject to certain specific provisions. For the same reason, we are also proposing CSAs to similar provisions in Part 2 of the bill concerning other electoral laws, and this involves the clauses 5, 8, 13, 16, 22, and 27. Later on, I'll move new 7A and 10A. And the proposed new section 62A of the Registration of Electors Appeal Regulation, Cap 542B, and the proposed new section 72A of the Election Committee Registration Voters for Subsectors, members of EC Appeals Regulation, Cap 569B, be refined to make clear that the period for review of the ruling in respect of the appeal, claim, or objection in question will be extended to the next working day, which is not an increment whether day following the postponed deadline for the making of representation writing to the revising officer in relation to that appeal, claim, or objection. And we have also made cross-references. And in fact, this will involve clauses 17, etc. We have already briefed the Bills Committee, and also they have also supported our amendments. I will urge members to support our CSAs. Does any member wish to speak? Mr. Chen. Thank you, Mr. Chairman. For Division 2 of Part 2, in relation to increment weather, I would like to share my views. Clause 5.4 is the main point to be amended so that bracket 2 and bracket 3 will be subject to 541D in relation to increment weather provisions. For Schedule 2, it means that when there is a typhoon, the polling day and the counting will be adjourned. In this provision, it is said that during the LC election, certain electoral deadlines, should they fall on a working day, that is between Monday and Friday, or in specified circumstances, it is a Saturday, and within the office hours, should there be a typhoon signal or there is a thunderstorm warning, then it will be postponed by 1 day or 1 working day. And then in clause 5, for the 2 scenarios outlined in the first scenario, this is about the new 2A, bracket 2. And it says that on that day or a certain act being done on that day or on a day before that, and should inclement weather be encountered, then the activity should be adjourned by 1 day when it is not an inclement weather day. Now for 2A bracket 3, this is a new provision. It says that during that period of time, if a certain act has to be done, and if a certain act is allowed or permitted to be done, and if the last day of the period is to fall on an inclement weather day, then the deadline should be extended to the following working day, which is not an inclement weather day. For Cap 541D, Section 29(3), it says that 10 days before the polling day, and then the polling stations should be listed. And then Section 31(1) says that in contested elections, 10 days before the polling day, the chief election officer should sent out the polling cards. In the past, the arrangements were such that, generally speaking, the polling day would fall on a Sunday. And in accordance with what I have read out, the CEO, the Chief Electoral Officer, 10 days before the polling day, that is on a Thursday, before that, the polling cards have to be sent out. But then the relevant provision would only say that the latest that the CEO should send out the polling cards would be 10 days only, rather than serving the polling cards 10 days before the polling day. So there's no way to assure that the electors would certainly receive the polling cards. The CEO doesn't have the responsibility to do so. Say, for example, within the office hours of that Thursday, which is 10 days before the polling day, and then if there is a number 8 typhoon signal and it's only lowered on the Friday that follows, then the polling cards to be sent out will have to be adjourned until the next working day. That means the Monday before the election day, the polling day. But then we're talking about 2 million to 3 million electors. Can we assure that all the polling cards can reach the electors within 7 days? We know that many electors have told us that sometimes they may not be able to receive their polling cards. So I think that under 2A bracket 2, I think we have to spell it out that for Cap 541D, in relation to Section 31 bracket 3, it should not be bound by Section 2A bracket 2, so as to make sure that the Chief Electoral Officer may send out the polling cards ASAP.
So there won't be any delays due to inclement weather in this particular task. So, well, I'm raising this because of our own observations. For clause Section 47(3), in the no electioneering zone, now 7 days before the polling day, the notice must be given to designate the zone, and also There's another provision to say that 1 working day before polling day, the electoral officer must give written notice to all the candidates. The place of counting votes for their particular constituency. But then, in accordance with 15(3), if 1 day before polling day, or I suppose in practice the electoral officers, the CEO would not leave it too late. But let's say he only issues the notice on the location of the counting station 1 working day before the polling day, and because of inclement weather, the notice could not be served. It could not be issued. And in accordance to 2A(2), the chief electoral officer may give the notice on the next working day, that is on Monday. So that means it's only after the polling day that the CEO may notify the candidates of the counting station location after the polling day. This is rigid arrangement. I'm just pointing out that this could happen. Of course, never happened. But if you just read from the provision, that's the statutory arrangement. So in theory, what I said could happen. I'm sure the Secretary would say just in a moment that this is not bound to happen. But if you read from the provision, there is a possibility of this happening. And I'd like to point out that in September, district council elections usually in November. September is the typhoon season for Hong Kong. So if there's polling in September, or if polling is in November, then the registration and many processes may be carried out in September. September is our typhoon season. And there could be the number 8 typhoon signal. In 2008 and 2013, in April and September, there were occasions of the typhoon number 8 signal being hoisted in September. There were twice two such occasions. So it was a time. It was actually within the nomination period of the district council election, and of course for electoral election is usually held in September. So that's why the administration must be very careful and consider all possibilities. So as you plan your electoral tasks, you have to take into account such possibilities. Does any other member wish to speak? Mr. Ray Chan. Thank you, Mr. Chairman. For this session of joint debate, it's about the original provisions and the amended provisions. And due to inclement weather, there will be extension of some deadlines in relation to election. Now, I'll first of all speak on the overall arrangement before I speak on the specific clauses. There are now provisions in the relative electoral legislation on voter registration and electoral procedures. Deadlines are set for these procedures in the relevant provisions. There could be deadline for voter registration, deadline for electoral officer to provide further information by candidates, or deadline to to make inquiries. The deadline for changing the omissions list, and claim, appeal, or objection deadlines. So revising officer ruling on objection claim or appeal. There are deadlines for all such procedures. So there's a specific provision proposed here, that is, let's say on a particular deadline, that's inclement weather warning, then the statutory deadline should be postponed to the next working day, which is not an inclement weather warning day. This is to allow for the this is to make up for lost time for completing the relevant procedures. Well, we could understand the legislative intent, but of course the weather is unpredictable. Apart from typhoon number 8 signal or red or black rainstorm, there could be other inclement weather conditions. I understand that Bills Committee, some members asked whether for similar cases the deadline extension could be allowed. So we could make up for lost time due to such special circumstances. For example, landslide warning, thunderstorm warning, flooding warning, and so on. Because all these may affect voters' registration or elections. Some members propose that in the case of force majeure, the relevant deadline could not be observed, then there should be extension of the statutory deadline. The administration replied that if we introduce the term force majeure, the definition is vague. And if we introduce this concept in electoral legislation, it will lead to a high degree of uncertainty. And in specific cases, if such a concept is to be applied by electoral officers, it might lead to disputes, especially because some people, like the candidates or voters, if some of these candidates or voters could complete the required act within the statutory deadline, but then there are others who have missed the deadline and they try to resort to force majeure as a defense, then it could lead to a lot of disputes. Yes, I could understand. The administration doesn't want troubles, or let's say it's not that they don't want troubles, but just that if there are more provisions for extension deadlines and so on, it would just lead to dispute. Let's say in my district there's a flooding warning. I couldn't leave home. I couldn't send in my registration form, so I'm not able to participate in the election. So as we designed a system, of course these are just concepts we bear in mind. Now, especially for people who want to run an election, probably they won't leave it till the last day to submit their nomination. For example, if 100 nomination, you need 100 names to support your nomination, and then some fill in false information, and then only 95 nominations are valid. Then you're short of 5, right? Then you'll be in trouble. Let's say in my district there's inclement weather. Maybe it's not even typhoon number 8 signal, maybe just in number 3 signal. Then in such weather condition, where do I go to find 5 more to support my nomination? So it would be difficult. That's why I would suggest that for all aspiring candidates, it's better if they submit their nominations sooner rather than later. They mustn't leave it till the last day to submit their nominations. I said the same to the Financial Secretary. You mustn't draw the line this way, because it could be typhoon number 8 signal, and then that we can't have a meeting, and then whatever proposals you want to get passed won't get passed. So it's the same reasoning. Anyway, I've talked on the broad principles. Let me focus on the specific clauses. Clause 5. in accordance with Section 2A, bracket 3, there is another scenario to what Mr. Albert Chan said. That is, for this provision, certain act must be carried out within the specified period. And the last day, if the last day of the period falls on an inclement weather warning day, then for such an act, therefore the time frame would the period would be extended in relation to the act to end on the next working day, which is not an inclement weather warning day. So this is Cap 541D, Section 7.2. That is 29 days before polling day, or between 29 days and 42 days before polling day, the nomination period would end. There is no amendment in this bill to this period, but then it will be affected by Section 2A, bracket 3. That is for the last, let's say that for the last day of the nomination period, there's an inclement weather warning, and so the period will be extended to the next working day. But then it would be strange because it so happens if the last day of a nomination period does not fall on an inclement weather warning day, then there will be no extension. But some people may only submit their form on the last day of the nomination period, because once they've submitted their form, that means they've accepted their nomination. Then for all publicity expenses, they have to be declared as election expenses. So if, of course, fortunately, in the past, it's never happened that on the last day of the nomination period, if there was a typhoon number 8 signal or black rainstorm warning. So there's never been a case where people were prevented from submitting the nomination form on the last day of the nomination period. But if indeed on the last day of nomination period there is inclement weather, then the period could be extended to the next working day, which is not an inclement weather warning day. That's what the administration is proposing now. But then the administration has not proposed extending the polling day similarly. Now, if, say, the nomination period has been extended, then in terms of publication of the candidates list and the candidate number, the date of such publication is not extended because of an extension of the nomination period. That means that candidates will have less time to include his candidate number in his publicity materials, and so that may shorten the period for which candidates could carry out electioneering activities.
Well, of course, some candidates are smart enough to prepare publicity materials in all sorts of numbers. So as soon as he knows his election number, he can use his publicity materials. Take LC election in 2012. The last day for nomination is the 31st of July. It's a Tuesday, and the briefing was done on the 3rd of August. Now, assuming that typhoon signal number 8 was issued at 4 p.m. on the 31st, and it was only cancelled at 8 a.m. on the 1st of August. So the deadline of the nomination is extended to the next working day, which is the 2nd of August. And in 2012, the administration could only hold the briefing for candidates 3 days after the close of nomination, because it had to confirm whether the candidates were really qualified. And I think 3 days is reasonable. And because of that extension, the briefing had to be extended or postponed to the 5th of August. But then that is a Sunday. As a result, the briefing would have to be rescheduled to one further day beyond, and that's the 6th of August. That is 3 days less for publicity. However, the polling day was not postponed, so there would be less time for the candidates to publicize. and the administration would also delay in sending out information of candidates without postponing the polling day, and some voters may not be able to receive the publicity materials. So if the nomination deadline is extended by 1 day, can we do the same for the polling day? Now, as we all know, the polling day must be a public holiday to be fair to candidates. Can we consider postponing the polling day to the next Sunday to be reasonable? And according to the standards of the judiciary, there will only be an extension to the next working day when typhoon signal number 8 or black rainstorm warnings is issued. But if we go by the same standard, it's not appropriate. For instance, if on the last day of nomination there is typhoon signal number 3 issued or red rainstorm warning, I think the day should be extended by 1 day as well. For instance, if typhoon signal number 8 is issued at 3:30 in the afternoon, that is after a working day is closed, the day for nomination would not be extended by 1 day. But for those who live in not so accessible areas, if he would like to run in the election as well, and if he can only secure all the necessary nominations on the day, on the deadline, then it will not be fair. So can we add 2A, add the whole group of section 2A to the arrangements for polling day? This will be the simplest way of doing things. The administration may disagree, but if we have different arrangements for voter registration, for polling, and for nomination of candidates, perhaps there should be different arrangements according to the administration. Because of uncertainties, it may be difficult to consider all uncertainties one by one. But if we do it like this, in case the red rainstorm warning or typhoon signal number 3 is issued, the date can be extended to give more room for maneuver. The date of extension can be 1 or 3 days. Even if we give candidates or voters or all electoral activities a few more days to maneuver because of inclement weather, that's not asking too much. Thank you. Does any other member wish to speak? Mr. Albert Chen. I'd like to speak on clauses 27 and 28. These two sections are amendments to the Rural Representative Election Registration of Electors Appeals Regulation, Cap 576, Subsidiary Legislation A. This amendment expressly stated that 1A is subject to the regulation of 2A. The discretion can be given for extension of 1 day. Now, the crux of the matter is discretion, because we're talking about rural representative election. Most magistrates live in the urban areas. They may not have a full understanding of the conditions in rural areas. And if we rely on them to make a discretionary decision, that may not be appropriate. I myself have faced the very bad attitude of revising officers. Some think that revising officers, or rather some magistrates, do not understand ordinary lives of ordinary people. I saw how professional drivers hated magistrates. Of course, some of them are very sympathetic. They are sympathetic that ordinary members of the public are laymen in law and are entirely ignorant of the law, and they are very patient in guiding ordinary members of the public in front of them. But some of them are rather hateful. The decision to extend the date. Now, according to these clauses, it will be subject to the discretion of the magistrate. I fail to understand why the date of written submission cannot be extended by 1 day, or will be extended because of inclement weather. Why should we leave it to the discretion of a magistrate? In Section 27, 1A is added, and subsection 3 here applies to the regulation 25782C3. That is, no matter whether a person appears in person or is represented, he can make written representations, and the written representation can be delivered in person or by mail, and should reach a certain address at least 1 date before the hearing. It has to reach the revising officer 1 day before the hearing. Now, for rural elections, a very special feature is many of the electors or voters are elderly persons. Some of them are illiterate. Some have no understanding of the electoral legislation. Many villages are very remote. Some of them are not accessible by road. There is no ferry pier, and a person may have to walk an hour or so to reach proper road. So if they would like to make an appeal under this regulation, they have to deliver a written representation, and there can be a delay because of inclement weather. So for an elderly person who decides to submit his written representation on the very last day, now because of the fact that he lives in a remote area, even though the black rainstorm warning or typhoon signal number 8 is not issued, in some places, even when the typhoon signal number 3 is issued, there will be no ferry service. Places like Po-toi or other islands, because of the wind speed, ferry services can be suspended. Well, ferry services might not have been suspended, but for elderly persons, they have to risk their lives to submit such a form when the weather is so bad. This is inhuman. So it need not be typhoon signal number 8 or black rainstorm warning. I think we should give the person concerned the right to choose. And the submission of forms or appeals should be allowed to be deferred to the next working day. This is a more reasonable and a human arrangement. Anyway, this arrangement won't be unfair to other candidates or cause any injustice to the election. For instance, we can amend the section to say that when there is suspension of mail service, then the deadline for submitting written representations should be allowed to be deferred to the next working day. I think this is more logical and human. Does any other member wish to speak? If not, I invite the Secretary to speak again. Thank you, Chairman. Regarding the question of inclement weather, as I said in my previous speech, well, I do not have any supplement in terms of principle. However, regarding notification, well, sometimes because of a delay in mail delivery, the Electoral Affairs Office has got a hotline up and running for quite a while to allow relevant persons to inquire about the arrangements at polling stations. And regarding the polling date, Mr. Albert Chen said that notices for location of counting stations in Part 12, we have a corresponding amendment. Instead of 1, it is extended to 10 working days to give more flexibility and a discretion of the revising officer under Clause 28. I think it really hinges on whether the information involved is simple or complicated. And I'll put a question to you, and that is the amendments moved by the Secretary for Constitutional and Mainland Affairs be passed. Will those in favor please raise their hands? Mr. Ray Chen claims the division. The division bell will ring for 1 minute.
Please ring the bell to summons members to come back.
開始表決。
Voting begins. Members, please vote. Members, please check your vote. If there are no questions, voting is ended. The results are to be displayed. The result is members who are present 40, 39 are in favor, no objection, no abstention. The question has been agreed by majority of the members who are present. I declare the motion passed. Clauses 5, 8, 13, 16, 17, 19, 22, 23, 25, 27, and 28 as amended. And I'll put the question to you, and that is the clauses is read out just now, stand part of the bill. Please proceed to vote. Those who are in favor, please raise your hands. Those who are against, raise your hands. I think the question has been agreed by majority of the members who are present. I declare the motion passed. Secretary for Constitutional Mainland Affairs, you may now move the second reading of the new 7A and new 10A. Chairman, I move the second reading of the new 7A and the new 10A. And I put a question to you, and that is the new 7A and new 10A be read the second time. And I'll put a question to you as stated. Those in favor, please raise your hands. Mr. Ray Chen claims to wish, and the bell will be rung for 1 minute. Voting begins. Members, please check your vote. If there are no questions, voting is ended. The results are to be displayed. The result is members who are present 38, 37, 4, no objection, no abstention. The question has been agreed by majority of the members who are present. I declare the motion passed. The new 7A and the new 10A. Secretary for Constitutional and Mainland Affairs. Chairman, I move that new 7A and new 10A be added to the bill. And I put a question to you, and that is the new 7A and new 10A be added to the bill. I now put a question to you as stated. Those in favor, please raise your hands. Mr. Ray Chen claims to wish, and the bill will be rung for 1 minute. Voting begins. Members, please check your vote. If there are no questions, voting is ended. The results are to be displayed. Members who are present, 39, 38 for, no objection, no abstention. The question has been agreed by a majority of the members who are present. I declare the motion passed. The new the title before 105A. Division 2A Amendments to Electoral Affairs Commission Registration of Electors, Legislative Council, Geographical Constituencies, District Council Constituencies Regulation, Cap 541 Subsidiary Legislation A. 105B, new 105B. Section 9, amended Electoral Registration Officer to prepare an omissions list. And the new 105C, Section 10, amended Electoral Registration Officers to publish a notice that omissions list is available for proper inspection. The new 105D, Section 15, amended who may lodge a notice of claim. The new 105E, Section 16 amended Electoral Registration Officer to deliver copies of notices of objection and notices of claim to revising officer. The new 105F, Section 19 amended what is to be contained in final register. The title to the new 105G, Division 2B, Amendments to Electoral Affairs Commission Registration, Electors for Legislative Council, Functional Constituencies, Voters for Election Committee, Subsectors, Members of Election Committee Regulation, Cap 541, Subsidiary Legislation B, the new 105G, Section 2, Amended Interpretation, the new 105H, Section 24 amended Electoral Registration Officer to prepare an omissions list. The new 105I, Section 25 amended Electoral Registration Officer to publish a notice that omissions list is available for proper inspection. The new 105J, Section 31 amended who may lodge a notice of claim. The new 105K, Section 32 amended Electoral Registration Officer to deliver copies of notices of objection, notices of claim, and notices of appeal to revising officer. The new 105L, Section 35 amended what is to be contained in the functional constituency's final register. New 105M, Section 36 amended, who is to be contained in a subsector final register. New 105N, Section 37 amended, what is to be contained in an election committee interim register and an election committee final register. New 106A, the title before it, Division 3A Amendments to Electoral Affairs Commission Registration of Electors Rule Representative Election Regulation Cap 541 Subsidiary Legislation K. New 106A, Section 1 amended Interpretation. New 106B, Section 18 amended ERO to prepare omissions list. New 106C, Section 19 amended ERO to publish notice that omissions list is available for proper inspection. New 106D, Section 24 amended who may make a claim. New Section 106E, Section 29 amended what is to be contained in final register. New title before New 106F, Division 3B, Amendment to Legislative Council Ordinance Cap 542, New 106F, Section 32 amended Electoral Registration Officer to compile and publish electoral registers. The title before new 110A Division 6 Amendment to Chief Executive Election Ordinance Cap 569, new 110A Schedule, Section 4 amended, Electoral Registration Officer to compile and publish Provisional Register. New 110B Schedule, Section 14 amended, Electoral Registration Officer to compile and publish a register of voters. The title, the heading before the new 110C Division 7 Amendment to Rural Representative Election Ordinance Cap 576, the new 110C Section 17 amended, Electoral Registration Officer to compile and publish registers of electors.
Title to Part 3, Clauses 4, 31 to 35 and 103. The Secretary for Constitutional and Mainland Affairs has given notice to move that the title to Part 3, Clauses 4, 31 to 35 and 103 be amended, and that the new sections 105A, 105G, 106A, 106(4)F, 110A, and 110C, the division title before these new sections, and also new Section 105A to 105N, 106A to 106F, 110A, 110B, and 110C. Members may have a joint debate on these original provisions and the new amendments and the new sections. After the debate, the committee will vote on the title to Part 3, Clauses 4, 31 to 35, and 103. If these amendments are passed, the committee will then deal with the new division title before new Section 105A, 105G, 106A, 106F, 110A, and 103, and also the new sections 105A to 105N, 106A to 106F, 110A, 110B, and 110C. Secretary, I move the title to Part 3 and that clauses 4, 31 to 35 and 103 be amended. As I explained in the second reading debate, in response to the discussion of the Bills Committee, we're proposing to change the Chinese term of the omission list from the list of those removed to the list of those deregistered. This would better reflect the nature of the list, and a person's name will be removed will be delisted if the electoral officer is satisfied that he no longer is eligible as an elector, or he has voluntarily asked to be delisted. And this amendment involves Part 3, title to Part 3 of the bill, Clause 4, Clause 34 to 34, 3, 35 to 35C3, and 103. It will also involve the new sections to be moved later, that is Section 105A, 105G, 106A, 106F, 110A, and 110C, and the titles before these new sections. For these new title and provisions, Section 2, Division 2A of Part 13 and Sections 105A to 105F is to amend the Electoral Affairs Commission, Voter Registration, Legislative Council, Geographic Constituencies, the District Council Constituencies Regulation, Cap 541A. For Division 2B, Part 13, Sections 105G to 105N is to amend Electoral Affairs Electoral Affairs Commission, Registration, Legislative Council, Functional Constituencies, Voters, the Election Committee, Subsector Voters, Election Committee Members, Regulation, Cap 541B. Division 3A of Part 3, Part 13, Sections 106A to 106B is they are to amend the Electoral Affairs Commission, Voter Registration, Rural Representative Election Regulation, Cap 541K. And then Division 3B to Part 13 of 1065, that's the amended Legislative Council Ordinance Cap 542. In the light of the discussion of the Bills Committee, will also introduce amendment to Part 3 of the bill to spell out the procedure for voluntary deregistration of voters. We will spell out that the electoral officer will have to ensure certain conditions are met before sending the request to register a voter on his request. That is, for either the electoral officer has to receive, upon receipt of the registration notice from a voter, registered mail must be sent to the voter informing him that his entry will be removed from the next final register. And this amendments will involve clause 31 to 31.5, 32 to 33, 2, 3, 32, 7, 33, 2, 33, 4, 34, 1, 34, 2, 35, 1, and 35, 2 of the bill. In these cases, the Chinese term of omissions list will be amended. We have explained the relevant amendment to the Bills Committee. The Bills Committee support our proposal. I ask members to support these amendments. Thank you. Does any member wish to speak? Mr. Gary Fan. Yes, Mr. Ray Chen. Mr. Gary Chen. Gary Fan. Thank you. The Constitutional and Mainland Affairs Bureau has moved these amendments to the Electoral Legislation, the Miscellaneous Amendments Bill 2014. For voters who voluntarily ask for the registration, their names will be included in the omissions list, and I want to speak on that amendment. This bill covers voters who voluntarily ask for the registration, and the amendment will include them in the omissions list. And the amendments are to be moved to change the Chinese term of the omissions list from like a list of those removed to a list of those who have deregistered. They believe the change will better reflect the nature of the list, but the Neo-Democrat does not agree with the administration. Why? Given the current electoral legislation, the election registration officer is not empowered to include those who have asked for voluntary registration in the omissions list, especially the personal particulars of these people. It's not empowered to include such personal particulars. And in future, with the amendments, the election registration officer, if he's satisfied that a voter is no longer eligible as a voter, or if a voter voluntarily asks the election registration officer to deregister him, then the person's name will be included on the omissions list. But actually, the omissions list, this name cannot include those who ask for voluntary deregistration. That's why the administration is moving amendment to change the name, the Chinese name of the list, of the omissions list, to better reflect the nature of the omissions list. The Neo-Democrat believes that for voters who voluntarily ask to be deregistered, they have to be included in the omissions list, and that because that will ensure the accuracy of the number of voters on the final register too. But then the new Chinese term would actually not reflect the nature of the omissions list. Voter deregistration may be due to many reasons. If the omissions list is to cover those who've been removed as well as those who voluntarily ask for deregistration, actually the new name will make the nature of the list more vague. And for people who want to check the omissions list, they may be confused. That's why the Neo-Democrats proposes that under the omissions list there should be a sub-list to cover different categories. One category for those who voluntarily ask for deregistration, those who are removed from the voter register because they are deceased, or those who are mentally incapacitated, and also those who are registered by the electoral registration officer. So there should be 4 different categories. It will make the list clearer, and it will be easy for people to check the list. And when people inspect the omissions list, they don't have to go through all the different categories. The Neo Democrat believes the administration's amendment could not address all our concerns. During the scrutiny of the bill, the Assistant Legal Advisor of the Legislative Council Secretariat actually asked the question. Now, the registration office actually sends registered mail to the registered voters. They would verify their identity before actually listing the voters. But then there could be practical difficulties. What if the registered mail is bounced? There is not a clear procedure now to deal with that. The administration replied that the general principle of the registering voter is that if the electoral registration officer is satisfied that a voter has been informed that his entry will be removed from the next final register, only then would the entry be removed, and then the voter will be included in the omissions list. The administration's amendment spells out clearly this principle, but the Neo Democrat believes the administration's amendment is just that the electoral registration officer must send registered mail to the voters for the name and the primary address of the voter. This will be removed from the next final register. And then the electoral registration officer is satisfied that a voter has been informed by registered mail or other means that his will be removed from the list. Only then could the officer remove the name and the primary address of the voter from the next final register. But then in the amendment, it does not explain clearly what if the registered mail is bounced on one or repeated occasions. How would that be dealt with? And what if a voter could not be informed through registered mail? Are there other means to deal with it? So the amendment does not explain that. That's why the New Democrat believes the amendment has not responded to the queries of the Assistant Legal Advisor of LegCo. On the procedure to include people on the omissions list, the administration should provide clearer provisions. Otherwise, there could be confusion. In the 3rd joint debate, that's the only point I'd like to make. So on voluntary requests from voters to be deregistered, these are my views. Thank you. Mr. Ray Chen. Thank you, Mr. Chairman. On this joint debate session, now, the primary amendment is to change the Chinese term of the omissions list from like a list of those removed to a list of those deregistered. The administration believes that will better reflect the nature of the list, that is, the voters voluntarily asked to be deregistered. So I would like to speak on 2 fronts here. First, the Chinese term of the omission list. There's a proposed change here. The second point is about the process to deregister voters. In the provisional register, there are several categories of people who would not be included. First, if the electoral registration officer has a reason and is satisfied that a person no longer qualifies as a voter, then he will not be included on the list. That point is clear. And then during the statutory inspection period, someone asks the electoral registration officer to remove his personal particulars from the next final register. That's the second category. A third category is the one we're dealing with here. That is, as people ask, someone asked to be removed from the list voluntarily. Now, during the second reading debate, I said, explained under what circumstances people may ask to be deregistered. Like in my mother's case, she was made to register. Someone registered her for her. And so that's why we voluntarily asked for the registration in a case so that people couldn't use her vote. Now, for the first and second category of voters, they are included on the admissions list. The first two categories are those who do not ask for voluntary deregistration. The third category is for those who ask for voluntary deregistration. Now, we want to make sure that the provisional register and the omissions list tally in terms of the information they contain. And so for a voluntary, those who ask to be voluntarily deregistered, their entry should be included in the omissions list. So this will better reflect their position. And then because those on the omissions list will have their entries removed from the next final register. So this point is clear. At the Bills Committee meeting, some members commented on the Chinese term of the omissions list, which means the list of those removed. And it would not cover voters who voluntarily ask for the registration. The administration has taken on board members' views, so it's proposed to change the Chinese term of the omissions list from the list of those removed to the list of those deregistered. The administration says that it will better reflect the nature of the list. But I beg to differ. That's why I'd like to make my point. In many legal provisions, the English and the Chinese versions may not entirely tally. Actually, different terms could be used. Now here, the Chinese term is changed. How come for the English term is not changed? If it's the admissions list originally is translated into the list of those removed or removal list, then how come for the Chinese for the English term of the omissions list, how come it's not changed to say the registration list? Omissions list, and where does it include the meaning of registration? If we go by the original translation, omissions could be stretched to mean those removed from the list. So that's why I think we should also amend the English term to say it's a deregistration list. I think it's better that way. Because in the English term, I don't see in the word omission where there is the meaning of registration.
I think the term registration has got two levels of meaning. The first level is those who have registered to become registered voters, and subsequently they are removed or they are deregistered, whether it is a decision made by the ERO or by the elector himself. And the second level of meaning is those who are applying to be registered. So for the second level of meaning, it has nothing to do with what we are discussing now. That is, now we are referring to three categories of persons. And we believe the Chinese term 取消登記名單, meaning a list of those who deregistered, can better describe the group of people who have ceased to be registered. Now, omission list seems not to cover those who have voluntarily requested voter deregistration. But the new Chinese term has covered some persons who should not be included, leading to misunderstanding or unnecessary understanding. The original term 遭剔除者名單, a list of those removed, would refer to the power of the electoral authority. Even if an elector has voluntarily asked to be removed, the ERO has to exercise his power to take his name out or to take his elector particulars from the list before that can be effected. So even though the elector has volunteered to have his name removed, there has to the power has to be exercised by the ERO. I don't like the Chinese name Zhou, meaning is in the passive tone, and as Miss Claudia Mo said, this word, this Chinese character Zhou, is very often used in the negative sense. Perhaps it's because of this word that members think that this will give a negative impression and is against the amendment intention. In fact, according to administration, to ensure that the provisional registration and the omission list have information that tallies, we should include all the names on the FR on the OL, so the people will know that the names will be removed from the next FR. So why can't we use this Chinese rendition of omission list, 待除名者名單, meaning a list of persons pending removal, so that this will include those whose names are still in the FR but will not appear in the next FR. So why can't the administration consider this suggestion? Of course, by now it is already too late, and I have just advanced my argument in this debate. I hope that in future we can consider using this Chinese rendition, 待除名者名單, meaning a list of those pending removal. Now, I'd like to talk about the handling of requests for voter deregistration. According to the administrative procedures of the REO, when the office has received a signed written notice of deregistration from elector, the office will issue a notice confirming the deregistration by registered post to his or her registered address in the existing FR to inform him or her that his or her entry will not be included in the next FR. That means this registered mail, once it is successfully sent without return, the process is completed. And what will happen as a result? For instance, people who have moved overseas might request to be deregistered because they don't want to be electors in Hong Kong anymore. Perhaps he is no longer using his previously registered address. So even though the deregistration is confirmed with a notice sent by registered post to his registered address, now if that registered address is no longer valid, the person has moved out, he has sold his flat, then, well, what happened to his deregistration? Will it become invalid, or can he provide an overseas address or an address which is not his registered address since he's no longer living there? Can he submit another address for the REO to send this notice confirming his deregistration by post? Now, according to the administration, if the registered mail is undelivered, ERO will find out the reason and follow up to seek further clarification from the elector. I think difficulty is the elector cannot be traced. Perhaps he has become a street sleeper. He has no address. How can you find him? How can you locate him? The general principle is that if ERO, in its opinion, the elector concerned has been informed of ERO's intention to omit the elector's entry from the next FR, the ERO will include an elector's entry in OL on this basis, on the basis of his or her request for deregistration. So I want the administration to reconsider how the mechanism can be improved, because this deregistration mechanism is to respect an elector's choice to opt out. However, I don't want the process to be too complicated or technical hurdles to exercise his option. Thank you. Does any other member wish to speak? Mr. Albert Chen. Thank you, Chairman. I have 3 points to make on this part of the bill. First, the Chinese rendition of the term omission list. Now, if we can include all electors of functional constituencies in the omission list, then all FCs are abolished at once. And I think that would be a major progress and would be the most wonderful amendment of all if we can put all FC electors in the omission list. That would be wonderful news to all in Hong Kong. All right, that's just a wish, and I will go back to the provisions. I think the ERO can go an extra mile. As we all know, when we had elections earlier on, you need only to look at the list and you know that for some flats there were bound to be problems. We've seen a unit with more than 30 electors registered, and it turned out that it was an address of some patriotic companies. That was in the 1980s. And some electors used company's address or the organization's address for registration, even if it is a residential address. Well, frequently we saw 6, 8 registered electors in the same flat, but they can be grouped under 2 surnames, and we could deduce that probably the one family used to live here and had moved away. So the ERO should make use of his computer system to check such irregularities. If it is found that in a residential unit there are 8 registered electors, the ERO can first do some research and take follow-up action. And administratively, when he is compiling the omission list, he can carry out some investigation and even send letters to these suspicious units asking for a confirmation of status. The ERO can be more proactive using administrative means to investigate possible irregularities. Perhaps because of numerous complaints, the RO is now more proactive. For LC elections, it is a bit difficult to confirm, but for DC elections next year, I hope the RU could really check the FR very carefully to see whether there is any vote rigging. I think at peak there were 23% of the electors registered in problematic addresses. So I hope that was something in the past. I hope the REO can take proactive measures to confirm the real status of electors. Of course, some of the cases related to vote rigging, but I would say for the majority of the cases, it was because people have moved and have omitted to update their personal particulars with the REO. So regarding the omission list, I hope that the Secretary can pay particular attention. A couple of years ago, I handled a case where a person was put in the omission list, and the person concerned was felt rather angry for 1 or 2 years. He wrote and complained to the relevant authorities, and just he found out that his name was removed. He was among the 200,000 voters removed from the FL. Because of allegations of FL, there was investigation and some names were removed. I think there's something wrong with the process. Letters were sent to him asking for confirmation, but perhaps there was some error in mail delivery, or his family did not hand over the letter to him. Anyway, without his knowledge, he was removed from the FL. The case I handled was when he was made aware of that fact, the deadline for voter registration was not passed, and he already told the relevant authorities of his case, and he wanted to be included in the FR again. But perhaps of mishandling of the officers concerned, or maybe because of procedural matters, his name could not be put back to the FL. Anyway, on the date of election, he was found that his name was not on the FL. He was not allowed to vote, and he was so angry because he wanted to vote to show his position. But he did complain to the relevant authorities before the deadline, telling them that his name was wrongly removed, and yet he was not reinstated. So it goes to show that in the removal of electors and re-registration, there is something wrong with your procedures.
And we have talked to the REO a number of times. We did talk to the REO, but still his name was not re-entered into the register. The Secretary should seek improvements to prevent a recurrence. Does any other member wish to speak? Secretary. Thank you, Mr. Deputy. Concerning the division referred to by Mr. Gary Fang, with regard to the omissions list, well, it will be exhibited for public inspection together with the voters register. It will be part of the information on who will not be listed in the next voters register. So for ease of access, we would list the name in the order of Chinese character, and then in alphabetical order for the English names. So we would like to stick to this approach to facilitate checking. I've heard Mr. Chi-chuen concerning the Chinese term and English terms, for example, omissions list. Mr. Chen may wish to check any dictionary through his mobile phone. And I believe that one of the meanings of omissions will be the one we are suggesting now. So what we are proposing in terms of the name, what we are proposing can be covered by the term omissions. And then mention has been made about follow-up of cases, use of registered mail in the past 2 to 3 years. Because of the concerns of vote rigging, our colleagues in the REO did use very stringent procedures to check. Apart from the statutory procedure, we also resort to a two-letter system. And if the voter also gave us the email or other means of communication, we try to contact the voter through those other means. So before the person is delisted, we'll pursue the matter through various means. And also Mr. Albert Chan has asked us to check whether there are whether we have many voters registered under the same address. For the 2016-2017 elections, we continue to work hard, and we will adopt stringent criteria in checking to ensure the integrity of the system. I agree with the observation of Mr. Chan that very often such cases of multiple voter registration within the same flat is due to the previous occupants having moved to a new address. So we would like to urge our voters to update their addresses as and when appropriate. And I'll put a question, before I put a question to members, I want to remind members, if the Secretary's amendment is not passed, then he cannot move the newly added 105A, 105G, 106A, 106F, 110A, and 110C, and the headings to the new subdivisions, as well as the newly added 105A to 105N, 106A to 106F, 110A, 110B, and 110C. And I put a question to you, and that is that the amendments moved by the Secretary for Constitutional Mainland Affairs be passed. Would those in favor please raise your hands? Mr. Chi-chuen claims a division. The division bell will be rung for 5 minutes.
夠喎，夠喎。請議員表決。
Voting begins. Please verify your votes. If there's no question, voting is closed, and the result is displayed. Members present, 36, 35 for, no one against, no one abstained. The question is agreed by majority of the members present. I declare the amendments passed. Heading of Part 3 as amended. Clauses 4, 31, and 30 to 35 and 103. And I'll put the question to you as stated. With those in favor, Mr. Chen Chi-chuen claims the division. The division bell will be rung for 1 minute. Voting begins. Please verify your votes. If there's no question, voting is closed and the result displayed. Members present, 37 present, 36 for, no one against, no abstention. The question is agreed by a majority of members present. I declare the amendments passed. Secretary for Constitution and Mainland Affairs, you may now move newly added 105A, 105G, 106F, 110A, and 110C, and the heading before these new divisions, as well as the newly added 105A to 105N, 106A to 106F, 110A, 110B, and 110C. Secretary. Chairman, I move the clauses and heads as you have read out. And I'll put a question to you then, that is that the newly added clauses and new headings be added to the bill. And I'll put a question to you as stated. Mr. Chen Chi-chuen claims the division. The division bell will be rung for 1 minute. Voting begins. Please verify your votes. If there's no question, voting is closed and the result displayed. Members present, 37, 36 for, no one against, no abstention. The question is agreed by a majority of members present. I declare the motion passed. the heading to the new divisions before 105A, 105G, 106A, 106F, 110A, and 110C, as well as newly added clauses 105A to 105N, 106A to 106F, 110A, 110B, and 110C. Secretary for Constitution and Mainland Affairs. I move that the clauses and new heading be incorporated into the bill. I now put a question to you, and that is those newly added head and clauses stand part of the bill. I now put a question to you as stated. Mr. Chen Chi-chuen claims a division. The division bell will be rung for 1 minute.
Please ring the bell. Members, please cast your votes. Members, please check the votes you've cast. If there are no queries, the results are displayed. 35 present, 34 yes. No no's, no abstention. The question is agreed by a majority of the members present. I declare the motion passed. Heading to Part 5, clauses 39, 40, 42, 43, 45, 46, 47, 49, 50, 54, 55, 58, 59, and 61. Secretary. Chairman, I move the amendments to the above clauses. Part 5 has to do with the doing away with the prior notification concerning appointment of counting and polling agents. As I said in the resumption of second reading debate,
debate. The intention is to simplify the procedures and to facilitate candidates' work during the election. And the amendments will not cause excessive risk concerning fairness to the election and the smooth conduct of the election. But we understand members' concerns. They are of the view that we should proceed prudently. They are of the view that the status quo should be maintained. And so we would like to introduce an amendment to withdraw the new proposal. In other words, the status quo we maintain concerning the appointment and the revocation of appointment of counting and polling agents. And there are also a number of technical amendments, and these amendments involve the heading to Part 5, clauses 39, 40, 42, 43, 45, 46, 47, 49, 50, 54, 55, 58, 59, 61. We briefed the Bills Committee on the proposals, and the Bills Committee expressed support. We hope that members can support these amendments. Does any member wish to speak? Mr. Aberchan. Thank you. Chairman, I understand that a fait accompli has been created. I want to say that, in fact, the original intention of the administration should be supported. Under the original proposal, counting and polling agents can be appointed on election day. Not all candidates have a lot of resources. Not all political parties are as big as the DAB. Now, you know that the DAB as a party has over 100 staff members, but PP only has half a staff member. And when I talk about the 100 odd staff members of the DAB, I haven't taken into account their members' assistants. And in fact, they have 20 to 30,000 members, and so they can easily mobilize 10,000 people to help in the election. And so we should welcome arrangements that would facilitate the work of candidates who do not have a lot of resources, who do not have a lot of manpower support. So they can fill in the form and submit it on the same day. Now, maybe on election day, the candidate may come across someone he knows on the street, and then may ask him or her to help out. And when candidates are distributing pamphlets on the street, they may come across friends who have some experience in election campaigning. Some candidates may only be able to find someone to help them at a very late stage. And it may be at a very late stage, immediately before the election day, that some candidates suddenly remember that they need to appoint counting agents and polling agents. So the proposed arrangements can facilitate the work of candidates with less resources. I am not a member of the Bills Committee, and I believe those who opposed the arrangements in the Bills Committee should be members who belong to the DAB. I believe independent candidates and candidates who do not have a lot of resources should welcome such arrangements. Only members from large political parties may or will object to such arrangements. But then we are a small party. We can't send members to sit on each and every Bills Committee. And the administration immediately decided to withdraw the proposal when there was objection from the power and influential members. In fact, the idea is a good one, but the Secretary has decided to withdraw the proposal. And Secretary, if you continue to stay in this post, and if in future this piece of legislation needs to be amended again, I hope that you'll reconsider the proposal, and I'll not rule out the possibility of my moving a private member's bill on this matter. Thank you. Mr. Kwok-him. Thank you, Mr. Deputy. Mr. Albert Chan criticized the big political parties. He criticized the so-called powerful and influential members. Albert Chan, I think you should check the records. You should listen to the audio recordings of the debate. In fact, the DP, Labour Party, and the Civic Party were against the amendment. The DAB was not against the idea. They were of the view that the arrangement would cause confusion and chaos. And as a result, the administration decided to withdraw the proposal. So the administration has decided to move this amendment because of objection from members which are not influential or powerful in your eyes. So I think you should always listen to what people say. You can listen to the audio recordings if you need to. Now, in fact, I want to say, Chairman, that the DAB supports the idea. Some political parties do not have a lot of resources, and the arrangements proposed are helpful to these candidates. But of course, I can understand the concerns expressed. But counting and polling agents in fact can be appointed on the spot, but they must be accompanied by the candidate concerned. And in fact, the DAB can accept this amendment. Mr. Chi-chuen, yes, Mr. Deputy, I just wish to supplement. So when the administration put forward a proposal, there was objection raised by some members. At the moment, there is a need to give 7 days notice for the appointment of polling agents and counting agents. So can you shorten the notice period to 5 days or 3 days? So some members expressed concerns. Maybe you were worried that if you did not heed the members' concerns, then if anything went wrong, then the administration would be blamed. I don't think we have ever had cases of fake polling agents or counting agents, but I don't think there will be impersonation or this impersonation problem, because you will be able to do the verification, and also, in fact, impersonation is a very serious offense. But of course, nowadays, anything can happen. For example, in Taiwan, it was said that a ballot box suddenly became empty, and some of the ballot papers were gone. In fact, it didn't occur to us that such strange things could happen in this council. For example, certain items can be passed despite very strong objection from electoral members and from members of the public. And so in future, when we have genuine universal suffrage, and when we have full confidence in the government, we are not worried that the government will manipulate the election, and when we are confident that no one can tamper with the ballot boxes, and so on and so forth, then perhaps we can adopt a more relaxed approach. Mr. Albert Chan.
Since I did not take part in the work of this Bills Committee, I might have speculated wrongly some of the discussions, and I must apologize to the people concerned because I have to admit it when I'm wrong. But in any system, with regard to any decision, it's always a balancing act. When you make a decision, some parties will stand to gain and some parties may stand to lose. To the candidates, polling agents and counting agents are relatively important. Actually, in polling stations, there have been irregularities, and also at counting, sometimes we may argue over a vote and whether it is valid, and sometimes the argument can be very fierce. Sometimes the chop is a little on the side, and then you may argue for it, so the returning officer may allow it. And there was one DC election when the winner only got 2 more votes than the loser. So with regard to inappropriate behavior at counting and polling stations, I think the agents have a central role to play. And as to these irregularities, well, in recent years, many members of the public have been telling me that civil servants managing the polling stations, are they going to act in a prudent manner? Because the pro-establishment camp would be manipulating everything, and the police force are also biased towards the groups starting with the word love. So if the police officers are giving the public the impression that they are biased towards certain groups in the community, how can you convince the public that polling station staff are politically neutral? This is the worry of the public, and the public are now having less confidence in civil servants, and I believe the situation will just become worse. Now, of course, we know many of the civil servants who are in charge of polling stations, and I think many of them act in an unbiased manner. But we also know that there are civil servants who are now biased towards the groups with the word love, and they may also manage or be in charge of polling stations. Therefore, if in the end we find a polling station, a polling agent or counting agent, then I believe as much as the system is concerned, then during the election, during polling and also counting, if the agents can have participation, I think it will add to people's confidence. And also there could be better monitoring. So any faking, any impersonation is criminal, and you want to know whether it's worth it if you are the candidate and if you are the one assigned to impersonate an agent. If you are discovered, it will be a criminal act. Do you want to commit a criminal act just to become a polling or counting agent? You say you are worried about impersonation, so you don't want to have this provisional appointment system. Well, then I would say if you are familiar with elections, I think there is a very slim chance of this happening. But as I said at the start, we, of course, are only looking back with hindsight, but I still like to have this recorded, that this change and then changing back, I think it is quite unfortunate. So I'd like to put on record these views of the people power. Ms. Sito. Thank you, Mr. Deputy. I took part in the scrutiny of the bill, and when the Bureau Secretary proposed this new arrangement, the first thing we said was why, and that is, if it ain't broke, why mend it? If there have been no complaints, why do you want to change it? Mr. Lee from the REO explained to us that this is to facilitate candidates who would like to appoint counting agents there and then. But then at the meeting, members immediately asked more questions. Actually, at the polling station, the returning officer already has a lot on his plate. There may be 10, 20 lists. And from 7:30 in the morning to 10:30 in the evening, candidates may suddenly show up and bring polling agents or counting agents to the presiding officer to be appointed. Well, actually, that is some kind of unforeseeable work for the presiding officer, and that may not be ideal. And Mr. Alan Leong also said if the agent is not accompanied by the candidate and yet the agent brings other people to the stations, that again won't be ideal. And also, both the candidate and the polling agent are very busy, especially if it is a big constituency. And if they have to go in person, there is already some difficulty for them. Therefore, we believe that the REO's idea would facilitate candidates, but then this may not be utilized, and at the same time it may give rise to some downside which cannot possibly be prevented. And then we also asked another question, and this may not be big, but whether there will be enough space for these agents. Actually, there are not many stations which can allow 10, 20 lists to be represented at the same time. Very often you have to take turn. You have to stay in the queue and for someone to come out before you can go in. And if there is a long queue, you can only go in for half an hour or 1 hour. So the discussion was that the REO should find bigger polling stations so that the candidates and the polling and counting agents can ideally all go into the polling station at the same time to monitor the polling process. So I can confirm what Mr. Kwok-him said, that actually the Democratic camp and also Ms. N. Chang of DAB both felt that the original approach ain't broke, so it's better not to amend it. And it's really very rare that the Undersecretary said so almost on that occasion, that if you none of you would like to have the change, then let us not change it. Now later on, if we discuss other bills and policies, if we can forge a consensus so easily, and if the administration would not lead us up the garden path and then make a decision in order to align with the views and wishes of the council, then I'm sure we can have a better and smoother relationship between the executive and the legislature. Does any other member wish to speak? If not, I would ask the secretary to speak again as CMA. Thank you, Chairman. I will just add 2 points. In the discussion process, actually the original proposal as well as the present CSA each had its pros and cons, but during the interim period between elections, we will take stock of experience and then review such practical arrangements. Second point, the size of the polling stations. I'd like to mention a point. Very often when we identify polling stations, we may have difficulties. We would like polling stations to be near to residential dwellings, so people don't have to walk too far to cast the vote. If we need large polling stations, it is actually not so easy to find them in the community, and therefore there are objective constraints. But experience tells us that the administration has not received any complaints with regard to not being able to enter into polling stations to monitor polling. And without affecting polling, we would ask the presiding officer to arrange for people to go in. The committee will first vote on the CSA moved by the SCMA on the title to Part 5. I will now put the question to you as stated. Mr. Raymond Chan claims a division. The bell will ring.
現在開始表決。
Voting begins. Please verify your votes. If there's no question, voting is closed and the result is displayed. Members present, 35. 32 for, 2 against, no abstention. The question is agreed by majority of members present. The motion is passed. Heading to Part 5 as amended. I now put a question to you, and that is that the heading to Part 5 as amended stand part of the bill. I now put the question to the vote. Would those in favor please raise your hands? Mr. Chi-chuen claims a division. The division bell will be rung for 1 minute. Voting begins. Please verify your votes. If there's no question, voting is closed and the result displayed. Members present 38, 37 for, no one against, no abstention. The question is agreed by a majority of members present. I declare the motion passed. The committee will now vote on the amendments moved by the SCMA regarding clauses 42, 43, and 58. Before I ask the Secretary to move the amendments, I want to remind members that if the above-mentioned amendments are negative, the Secretary may not move amendments to clause 49 and 50. And I'll put a question to you, and that is that the amendments moved by the Secretary for Constitutional Mainland Affairs be passed. Will those in favor please raise your hands? Mr. Chi-chuen claims a division. The division bell will be rung for 1 minute. Voting begins. Members, please verify your votes. If there's no question, voting is closed and the result displayed. Members present, 38, 37 for, no one against, no abstention. The question is agreed by a majority of members present. I declare the amendments passed. Clauses 42, 43, and 55, 49. I now put a question to you, and that is the clauses that are read out stand part of bill 39, 40, 49, 50, 54, and 55. With those in favor, please raise your hands. Mr. Chen Chi-chuen claims the division. The division bell will be rung for 1 minute. Voting begins. Members, please verify your votes. If there's no question, voting is closed and the result displayed. Members present 39, 38 for, no one against, no one abstained. I think the question is agreed by a majority of members present. I declare the amendment passed.
The
committee will now vote on the amendments moved by the SCMA or with regard to clauses 42, 43, and 58. Before I put the question regarding the amendments moved by SCMA, I would like to remind members if the amendments are negative, the SCMA may not move amendments to clauses 49 and 50. I'll now put a question to you, and that is that the amendments moved by SCMA be passed. Would those in favor please raise your hands? Mrs. Chen Chi-chuen claims a division. The division bell will be rung for 1 minute. Voting begins. Members, please verify your votes. If there's no question, voting is closed and the result displayed. Members present 38, 37 for, no one against, no one abstained. The question is agreed by a majority of members present. I declare the amendments passed. Clauses 42, 43, and 58 as amended. And I'll put a question to you that clauses 42, 43, and 58 as amended stand part of the bill. I'll put a question to you as stated. With those in favor, Mr. Chen Chi-chuen claims a division. The division bell will be rung for 1 minute.
開始表決。
Voting begins. Members, please verify your votes. If there's no question, voting is closed and the result displayed. Members present, 38, 37 for, no one against, no one abstained. The question is agreed by a majority of members present. I declare the motion passed. The committee will now vote on the amendments moved by SCMA with regard to clauses 45, 46, 47, 59, and 61. And I'll put a question to you, and that is that the amendments moved by SCMA be passed. With those in favor, Mr. Chen Chi-chuen claims a division. The division bell will be rung for 1 minute. Voting begins. Members, please verify your vote. If there's no question, voting is closed and the result displayed. Members present, 38, 37 for, no one against, no one abstained. I think the question is agreed by a majority of members present. I declare the amendments passed. Clauses 45, 46, 47, 59, and 61 as amended. And I'll put a question to you, and that is that clauses 45, 46, 47, 59, and 61 as amended stand part of the bill. And I'll put the question to members. Mr. Chen Chi-chuen claims a division. The division bell will be rung for 1 minute. Voting begins. Please verify your votes. If there's no question, voting is closed and the result displayed. Members present, 37, 36 for, no one against, no one abstained. I think the question is agreed by a majority of members present. I declare the motion passed. The Council will now vote on the amendments to clauses 49 and 50 moved by SCMA. And I'll put a question to you, and that is that the amendment moved by SCMA be passed. And I'll put a question to you as stated. Mr. Chen Chi-chuen claims a division. The division bell will be rung for 1 minute.
開始表決。
Voting begins.
請各位
Please check your votes. Voting is closed. The results are displayed. 37 present, 36 yes, no noes, no abstentions. The question is agreed by a majority of the members present. I declare the amendment passed. Clauses 49 and 50 as amended. And I'll put the question to you, and that is that clauses 49 and 50 as amended stand part of the bill. And I'll put the question to you as stated. Mr. Chen Chi-chuen claims a division. The bell will ring for 1 minute. Voting begins. Members, please check the votes you've cast. If there are no queries, voting is closed. The results are displayed. 37 present, 36 yes, no noes. The question is agreed by a majority of the members present. I declare the motion passed. Consider enactment by the Legislative Council. Secretary. Chairman, I would like to move an amendment to the Chinese version of the bill concerning the word enacted. We use the word 制定 the character 定 to replace another character 定. And this is to make sure that the wording will be consistent with that in the ROP. In fact, we briefed the Bills Committee on the amendment, and the Bills Committee expressed support, how the members will support this, the amendment. I now put the question to you, and that is that the amendment moved by the Secretary be passed. Does any member wish to speak? And I'll put the question to you, and that is that the amendment moved by the Secretary be passed. Mr. Chen Chi-chuen claims a division. The bell will ring for 1 minute. Voting begins. Members, please check your votes. If there are no queries, voting is closed. The results are displayed. 38 present, 37 yes, no noes, no abstentions. The question is agreed by a majority of the members present. I declare the amendment passed. Council now resumes. Third reading Electoral Legislation Miscellaneous Amendments Bill 2014, Secretary.